This is Barry Zalma on insurance for YouTube. How is insurance profitable? I am and have been for the last 52 years an insurance professional. I am now retired from the practice of law, but still work as a consultant and insurance claims expert witness. Today for YouTube, we're going to talk about how insurance works to be profitable. And it does so by maintaining, training, educating, and encouraging a professional claims staff, recognizing that it is the claims staff that keeps the promises made by the insurer, because every insurance policy is nothing more than a promise made to defend or indemnify an insured against any contingent or unknown event. Insurance is a contract, and it is nothing more than a contract that is limited by the terms and conditions of the insurance contract. It is not an entitlement. Insurance is not a benefit provided by the government. It is a relationship between an insurance company or an individual insurer with the policy holder. It has always been a contract of the utmost good faith. Therefore, the insurer is obligated to fulfill in good faith the promises made by the insurance policy. And the insured, of course, must also treat the insurer in good faith. The insurance contract is a mutual agreement between two parties. And just like the animals on George Orwell's Animal Farm, all parties to an insurance contract should be equal. But some, at least as applied by courts in the United States, are more equal than others. For example, an insured can collect damages for the breach of the covenant of good faith and fair dealing as tort damages as well as contract damages, while an insurer cannot. Considering the obligation of good faith that is imposed with greater effect on the insurer than the insured, it's necessary for an insurer to give at least as much consideration to the desires and funds of its insured as its own desires and funds. In fact, it probably should give more interest on the insured's desires and funds than the insured. So to begin, we must start with a definition of insurance. And the first duty of the insurer, of course, is to fulfill the promises made by the policy. In a third-party policy where an insurer promises to defend or indemnify an insured against its own torts against third parties, the insurer is obligated to investigate the claims and defend the insured to the allegations, whether false or fraudulent, and to pay all legitimate claims for which the insured is liable. In first-party policies, where the insurer agrees to indemnify an insured for damages to property, the risk of loss of which is faced by the insured, the insurer is obligated to investigate thoroughly all claims that might allow for indemnity for loss of property belonging to the insured, to determine if coverage exists for the loss, and to pay all legitimate claims promptly and in good faith. The third-party case usually comes up in a common auto accident, where an insured negligently drives his vehicle into the rear end of a car filled with 3 nuns and 2 priests, all of whom claim injury. All go to the same chiropractor, all are represented by the same lawyer, and all make offers of reasonable settlement. Every third-party liability insurance policy contains a promise to defend the insured to any claim or suit for which coverage is provided. Most policies have no limit on the amount necessary to defend the insured. Some, called burning limits policies, allow the cost of defense to reduce the limits available. Regardless, the duty is essential to the promises made by the insurer. And the duty to defend, of course, is broader than the duty to indemnify. The basic language of the commercial general liability policy promises to defend an insured against any suit seeking damages because of bodily injury, property damage, or personal and advertising injury. An insurer contracts to pay the entire cost of defending a claim, which has arisen within the policy period. And how is this defense provided? First, an adjuster is assigned to conduct a thorough investigation of the claim against the insured. The investigation covers all of the claims against the insured. The investigator collects evidence that can be used as part of a defense for the insured, and the adjuster determines whether the insured is liable in whole or part for the injuries claimed by the claimant. If the adjuster determines liability exists, he will attempt to settle with the claimant before suit is filed. When the adjuster can't settle with the claimant will retain counsel to sue the insured, and the adjuster will immediately, upon learning of the suit, retain defense counsel to defend the insured at the expense of the insurer. The adjuster will provide counsel, that is, the defense lawyer, with all evidence the adjuster has collected as part of the investigation, and the adjuster will ask counsel if additional investigation is required, and will perform the additional investigation as soon as possible. Consider a claim that alleged that an insured rear-ended the plaintiff on I-10 in Arizona on June 19, 2020. On June 19, 2020, the insured was in India at the time trying to catch a train. The insured has a passport and airline tickets proving he was not in the country at the time of the accident. The claimant refuses to believe he sued the wrong person and demands a jury trial. What must the insurer do if the plaintiff offers to settle for $10,000, a sum less than the amount necessary to defend? It cannot accept the offer. To do so would cause harm to its insured. To do so, even if the settlement demand is less than the expected cost of defense, would breach the promise to defend. To do so would breach the implied covenant of good faith and fair dealing. The insurer must thoroughly defend the insured through trial. The financial interest of the insurer cannot and should not overcome the obligation accepted by the issuance of the policy to protect the insured. The financial interest of the insurer cannot honor a false claim. There is no question the insurer would save money if it accepted the offer. The promise to defend is not limited by the expense incurred. So to settle a false claim for an offer based on saving the expense of defense only would be a breach of the promise to defend. The insured will not receive what was promised by the policy for which he paid good money, and the covenant of good faith and fair dealing might be violated. The covenant of good faith and fair dealing is, whether written into a contract of insurance, written into a statute, or just exists by judicial fiat, is a promise that the insurer will treat the insured in good faith and not do anything to impair or injure the other's right to receive the benefits of the agreement. The covenant is also a promise by the insured to treat the insurer in good faith and not do anything to impair or injure the insurer's right to receive the benefits of the agreement. When dealing with a first-party claim, consider a claim that the plaintiff alleges its property was damaged in an earthquake and demands money from the insurance company. The insurance company, ABC Insurance Company, provides the plaintiff with a copy of the policy that shows it first came into effect 1 year after the earthquake. Plaintiff refuses to dismiss and demands funds to settle. The insurer and its counsel refuse to pay and insist on winning the suit by summary judgment or trial. This was a real case. Scottsdale Insurance Company versus the law offices of Stephen Zelig. Scottsdale informed the public adjuster, Alan Capello, and attorney Zelig that the insured's policy did not provide coverage until 6 months after the earthquake. Nevertheless, a complaint was served on Scottsdale, and Scottsdale spent hundreds of hours of attorney time to win dismissal. It refused to pay tribute to Zelig or his clients. It obtained judgment and, in fact, sanctions against Zelig. It did not stop there. Once it obtained a judgment showing no coverage, Scottsdale sued Zelig, the attorney who insisted on going forward with the lawsuit after he was shown the policy did not even exist at the time of the loss. And the court, hearing the evidence, was not happy, and it issued severe sanctions against the lawyer. The lawyer abused the legal system. Claims, every insurance professional must understand, are not always honest. Some insureds will attempt to defraud the insurer. When an insurer believes someone is attempting fraud, it must assign its investigation to its special investigation unit, obtain the assistance and counsel of an experienced insurance fraud lawyer, and report the suspicion to the proper authorities. A fraudulent first-party claim, whether arson for profit or a fake theft, is one that must be defended totally and until there is a judgment. When I was a young insurance adjuster, I was taught that an insurance company should pay millions for defense but never a dime for tribute. And this was so because the insurance industry, at least it was so 50 years ago, is not an entitlement. It is not something that is given away. Insurance is a contract where the insurer agrees to indemnify another against an unknown or contingent risk of loss. An attempted fraud, by definition, can neither be unknown nor contingent. It is rather an intentional act that can never be insured. And because payment to get rid of an annoying and expensive lawsuit where nothing is owed because it was a fraud only reveals that the insurer is a pushover, that insurance fraud perpetrators who know each other and share success will come to that insurer over and over again as soon as the insurer is found to be an easy target. That insurer will be piled upon by an insurance fraud perpetrator. And that is why insurers must establish a program of never paying for tribute, because refusal to pay a false or fraudulent claim gains the insurer a reputation that it cannot be cowed, that there is no profit for a fraud perpetrator to fight an insurer who is adamant to go to trial, and the fraud perpetrators will therefore go to a different insurer who is easier to convince. Insurance fraud is evil. It must be fought. It is the law in most states that insurance companies are obligated to do everything possible to defeat insurance fraud and are compelled to maintain a special fraud investigation unit. If you wish to be part of the work to reduce or defeat insurance fraud, please consider my book, Insurance Fraud, and my other books on insurance available from Amazon.com and from my website at www.selma.com.